All right. Is everybody here that wants to be here? I see 4 lawyers. I think is there one more coming? Okay. I see a lot of lawyers. I see 6 lawyers. We got a full panel of Hollywood Square celebrities now. All right. So I'm going to say, if I ask if everybody's ready, the person about to talk first will unmute the mic and go. Fair enough. And how we divide this time again? I think you have an agreement among yourselves as to how to divide the time on what issues. Is that still in effect?
Yes, Your Honor.
All right, so I'll just trust you to keep track of your own time. Or as you begin, why don't we do this? Tell me what the agreed upon time the speaker has, and I'll try to help you with the time, okay?
Thank you.
All right, so let's begin.
May it please the court, my name is Chris Castillo. I represent the appellant Thomas Affey. I'd like to reserve 5 minutes for rebuttal if I could.
All right, you got it.
Thank you, Your Honor. This is a medical malpractice wrongful death case arising out of a bariatric surgery upon the deceased Deanna Affey. Thomas Affey is the personal representative bringing the claim. There was some pre-op clearance where Miss Affey was screened and showed that she had a heart murmur. They went forward with the surgery anyways. There's dispute as to the complications that resulted from the surgery and as to the actual cause of death. But she
Well, the issue is more procedural, right? Not substantive. About
Yes.
6 amended complaints and the last one being dismissed with prejudice, and that's the error asserted?
Yes, Your Honor. That's
All right,
correct.
just hone in on that. Why is that reversible error?
Yes, Your Honor. So there's actually, although it states it's a 6th Amendment complaint, it's actually only the 2nd amended complaint filed with the court. There's the original complaint filed on February the 12th of 15, which was dismissed on 6/19 of 17, granting leave to amend. Then you have the 4th amended complaint, which would actually be the 1st amended, which was filed 10/3/17 and dismissed 3/19/18, granting leave to amend. And then you have the 6th amended complaint filed April 3rd of 18, which would have actually been the 2nd amended complaint, and that was dismissed with prejudice on 9/17 of 2018. So in reality, only 2 amendments were allowed by the court. The misperception comes in with the fact that the appellant had filed multiple motions for leave to amend, mostly before the 4th, obviously the 1st, 2nd, and 3rd in the years 2015.
Well, that begs the question.
Yeah.
Did the judge say there's 6 amended complaints, I'm relying on that, dismissing this with prejudice, or the judge didn't hone in on a number and saying that's the sole rationale for my ruling?
The former, Your Honor, and it seems as though the judge had made up her mind on.
Counsel, let's talk about what happened at the hearing for a minute.
Yes, Your Honor.
When just before the complaint was dismissed with prejudice, in what was called at that time the 6th amended complaint, but now your position is that it was actually only the 2nd version out of 6. I'm a little bit unclear as to exactly what your argument is.
Yes, Your Honor. So there were actually only 2 amended complaints filed in this case. You have the original.
So the one that you were there, the one that was dismissed with prejudice, is that the 3rd version?
That would be the 3rd version, correct.
Let's assume that's the case for a moment. At the time it was dismissed, we were now 3.5 years after the initial suit was filed. Is that right?
That's correct, Your Honor.
And you had just before the hearing that resulted in the dismissal with prejudice, there had been an earlier hearing where the judge said in so many words, if you don't come here with something better than this that can withstand a motion, then I'm going to dismiss it with prejudice. So there had been some notice given that the next time you're there is going to basically be the last time, right?
Yes, Your Honor. I believe the lower court's words were, this is a last shot deal.
So the problem I'm having with it, given that as the backdrop, on page 26 of the hearing transcript, I think it was you there that handled the hearing, wasn't it?
No, Your Honor, it was not. It was the owner of the Florida Law Group, Chris Lambropoulos, who actually had made his first appearance at the September 17th hearing. The prior hearings were handled by Mr. Sparkman.
Were you there at the hearing?
No, Your Honor.
Okay.
I was not employed with this firm at the time of any of this.
Well, at the time of the hearing that resulted in the dismissal with prejudice, counsels were here recognizing that we're now here on a last shot deal. Counsel's argument consists of the following. I conclude this complaint is a mess, no question about that. So how is it an abuse of discretion for the judge to dismiss the case with prejudice, given that one more shot was given and the shot that was taken was conceded to be a mess? No question about that.
Absolutely, Your Honor. Because of this court's decision in Capley v. Borchers, as well as Your Honor's opinion in the Chobham versus City Mortgage case, which states that a pleading should have the opportunity to be amended unless it appears the privilege to amend has been abused or it's clear the pleading cannot be amended to state a cause of action. I don't think that anybody's arguing that the pleading cannot be amended to state a cause of action. I'll later argue that I think it's almost conceded by defense, especially I believe Dr. Fernandez in their reply brief. But the question is whether or not it's an abuse. Abuse, judges, is defined as to use as to a bad effect or bad purpose. The plaintiff had nothing to gain by continually trying to amend its complaints. And to address the time issue, Judge.
Well, at the time of the hearing, the version that was dismissed, which the court at least referred to as the 6th amended, there actually had been a 7th amended one that had been filed that same day. Isn't that right?
That's correct, Your Honor.
And then during the course of the argument, counsel conceded that even that 7th amended version may not be sufficient in light of some of the defense arguments that were being advanced. And there was an 8th version that was contemplated, correct?
I believe that's correct, Your Honor, but we disagree with that.
So, I mean, at some point, the defense lawyers, aren't they entitled to say, look, we've been at this for 3.5 years. We've got multiple versions here. We were given a last shot. The last shot came up as concededly a mess. I mean, I'm having a hard time finding an abuse of discretion by the way this trial judge handled this matter.
Absolutely, Judge. I think that goes more to a third prong, which is more in Your Honor's opinion in the Chobham v. City Mortgage opinion, where trial court's refusal to permit an amendment of a pleading is an abuse of discretion unless that it's clear that the amendment would prejudice the opposing party. Prong 1, the privilege to amend has been abused, or the amendment would be futile. And Your Honor cited to Laurencio v. Dutch Bank National Trust Company. As far as whether it prejudices the appellees in this case, I would say no, because they never argued that in any of their motions to dismiss, nor did they argue that at hearing. They cited to the case saying that it's one of the prongs the court could decide on, but ultimately what the lower court said was that this was an abuse of pleadings only after hearing the citation and the prongs cited by Mr. Willers at hearing. Prejudice was not argued by any of the appellees in any of their motions to dismiss or at either of the hearings. This was a contemplation that came up on the March 19, 2018 hearing and actually, Judge, if you look at the timing of the hearings, the March 19th, 18 hearing and the 9/17, 18 hearing when it was dismissed with prejudice are within the same year. It actually took the appellees having to schedule the original June 19, 2017 hearing. We filed the notice of hearing on 4/17/2017 on all of the appellees' original motions to dismiss. There was a large discovery period taking place during that time and some feet dragging by the appellees in getting their motions to dismiss for hearing. None of them were clamoring to get in the courthouse to have this case thrown out. It's not a futile case. There is a cause of action. It's acknowledged. So it's not futile. And as far as abuse goes, Judge, the case which they rely on most, the Gerstein case, the International Asset Value Group, that was actually the 4th amended complaint, which was dismissed by that court. That means there was 5 versions of that complaint. They continue to cite Cone v. City of Miami Beach, 4th amended complaint, that's 5 versions. Price v. Morgan, it was their 6th. And it goes down the line. Florida Gas v. Arkla Air Conditioning, 4 times. Myers v. Highway 46 Holdings, 4 times. McEwen v. Review Fin Printers Incorporated 4 times, Rodriguez v. Recovery Performance and Marine 5 times. There were only 2 amendments allowed by the court in this case, in a case involving wrongful death at the negligence of multiple tortfeasors. The woman aspirated on her own vomit and died, according to at least Dr. Lamella's, of aspirative pneumonia, which we can test that as well, but that's a dispute as to the facts. So, Judge, you have a case where appellees are dragging their feet, not wanting to hear their original motions to dismiss. And then you have the court making its decision on the March 19th, 2018 hearing, saying that she's making the decision that this is a last shot deal on her belief that there's an at least 2 dismissal rule. And that's in the record on page 1217, line 16, that she's saying there's an at least 2 dismissal rule, and that's why this is a last shot deal. There's a recovery effort made between Mr. Willers and the lower court on 9/17/18 to perfect the court's ruling, where she finally settles that this is an abuse, where this would only be the 3rd amendment, which had been filed. Your Honor, Justice Black, you continue to conclude in your Coburn v. City Mortgage opinion that leave to amend must be given freely when justice so requires, citing the rule 1.190A, and court should be especially liberal when leave to amend is sought at or before hearing on a motion for summary judgment in that particular case. But the same applies to a complaint under the rule 1.190A, which is what applies to this case. So it was actually given as a sanction, and that's cited actually by the court on the March 2019 hearing, saying, this is on the record, page 1148, which is the mini version. So it's page 50 within 1148, lines 3 to 11. So generally what we're anticipating, what we're going to come back for, because I'll be direct, I think it's pretty clear, I'm going to grant the motion to dismiss, and the court is likely to consider some sanctions down the road, something less than with prejudice for this, but obviously we're looking at coming back on the dismissal with prejudice. And then on 9/17/18, at the final hearing where it was dismissed with prejudice, you have Mr. Willers stating to the court, admitting there's no futility to the motion for leave to amend. What the defense is seeking, Judge, is essentially a sanction against the plaintiff because plaintiff's attorneys have inartfully pled their complaint. That's a concession that there's no futility, that there's a cause of action, and what the appellees are seeking is a sanction. They're not complaining of prejudice because this is taking forever. Nowhere do they complain of that. They're requesting of the court a prejudice, and the court is granting the motion with prejudice based on her belief that there's at least 2 dismissal rule, which I could find nowhere in any of the cases, and even the cases as earlier cited relied upon by the appellees does not exist, and that it's an abuse, and under her understanding that this was the 6th amended complaint, when she had in fact only allowed 2 prior amendments to this complaint. So it's very clearly not an abuse. There was very clearly a request prior to hearing as well as at hearing that the motion be able to be amended. And under the rule of procedure itself, in conformity with the Coburn decision as well as the Capley decisions by this court, not the Gerstein decision by the 4th PCA. And I would say even under that standard as well, there should have been, or justice demanded, that the appellant be able to leave to amend their complaint to state a cause of action, especially given the facts of this case. And so without further questions from the court, I'll yield the rest of my time for rebuttal. Thank you.
May it please the court. Dinah Stein on behalf of Dr. Wally Khan and American Heart Institute. And to remind the court, and as pursuant to the court's order, I'm going to take the first 10 minutes and then turn it over to Mr. Bush to address any type of sanction issue. And then Mr. DeLugo will take the last 5 minutes, loosely stated. I'm sorry, Your Honor, Your Honor, your audio.
Yeah, I know. I'm sorry. I apologize.
Thank you.
I was coughing. I don't want to display my coughing skills. I'm going to honor your request. You've already approved it, so you're good to go.
Thank you, Your Honor. And just to, first of all, to start with the facts, there were absolutely 7 complaints filed in this case. There were 7 complaints, 7 tries by the plaintiff to try to get a cause of action before they filed the attempted 7th amended complaint after being told that it was a last shot deal. But I'm going to quote plaintiff's counsel at the last hearing. This is page 55 of the transcript. The only thing that has not occurred is that a cause of action has not been appropriately stated through 6 amended complaints, and we concede that. The reason there were so many complaints is because the plaintiff's counsel was trying to respond, or I'm not sure what they were doing, but would respond to the motions to dismiss by filing a motion for leave to amend right before or the day of the hearings and say, really now we fixed it. The court did not fall into that. And to show how accommodating she was, if we look to each hearing, at the first hearing, the party showed up and said, we're trying to work things out. Plaintiff has filed a new complaint. She said, no, we're going to keep going into this pattern. I don't want to keep going in circles with motions to dismiss. She had every defendant state on the record their problems with the complaint and then turned to plaintiff and said, okay, here's your roadmap. Here's how to fix it. She not only did that, she told the plaintiff's counsel to send their next version of the complaint to defense counsel before filing it so they can comment on it and say what they might raise as a dismissal motion. The plaintiff sent it according to the record, but didn't listen to any of the defendant's concerns about the complaint and simply filed it. And that started the pattern. The 4th amended complaint inexplicably removed all factual allegations from each individual count against these separate defendants. It was incomprehensible as far as who did what. But again, they go to the second hearing. And this is now the plaintiff again comes up with a 5th amended complaint the day of the hearing and says, we fixed it now, we're done, we've cured it. Again, the court said, well, I don't want to keep doing this. And she again had every defendant lay a roadmap out as to what was wrong with the complaint. She even turned to plaintiff's counsel and said, what are you trying to say for each count? Well, you need to say that. And she said, I'm giving you a last shot deal. You've been given the roadmap. In fact, every motion to dismiss filed gave a roadmap as to what the plaintiff had to do to make a sufficient complaint, and plaintiff, for whatever reason, would not do that. Now, when we get to the last hearing, and this is really key because the only issue keyed up for this court, and which was keyed up below, is whether when you're now almost 4 years into litigation with 7 complaints, and the court again finds and plaintiff concedes that still no cause of action has been pled, they're saying the court has some duty, according to the briefs, to still look at any type of potential 8th, and in this case, 9th amended complaint or 9th complaint to see if maybe a cause of action could have been asserted. There's no such duty in the case law. And in fact, the court, when plaintiff's counsel conceded, they still haven't complied with the one-shot last deal that you need to get a complaint in. And we're asking for yet another 5 days to file another complaint. She said, I'm taken aback by this. I've given you every chance. And she said, at some point, in this case, I specifically find that the amendment process has been abused. So this was not a sanction. This was a finding based on a concession that there was no cause of action pled, and a finding that the amendment process privilege had been abused. That's all the court needed to do. It's pure abuse of discretion. And as she said on the record, I can't even see my discretion being questioned here when I'm faced with this. So this was not a sanction. This was not a Cozell issue. This was a pure and simple abuse of the leave to amend privilege. So, I mean, having said that, I think the record is very clear. The plaintiff got their day in court. They got it many, many times. They abused the process. They weren't able to plead a cause of action in this particular case. And the verdict, the judgment, the dismissal with prejudice should be affirmed. And unless your honors have additional questions, I'm happy to give the rest of my time to the other counsel. I think Mr. Bush was going to talk next.
All right, we'll go to Mr. Bush.
Thank you, Your Honors. My name is Derek Bush. I represent Dr. Lamalas and Bay Area hospitalists in this case. I had the benefit of being at all of the hearings at the lower court level where these motions to dismiss were considered. And I made arguments on each of these as well. And this has been a case, Your Honor, of a moving target on the part of the appellant in this case. At the trial court level, it was a consistently evolving and changing target for what was the operative complaint at issue at that time. As the court noted in Judge Black's questioning earlier, there was at least one occasion, actually two occasions, where on the day of the hearing with less than 2 hours notice, a new amended complaint was filed and counsel attempted to argue the facts and circumstances contained within that complaint rather than the actual basis that was before the court on the motions to dismiss. To now argue that there were only two complaints at issue, as Ms. Stein pointed out, is contrary to the concessions made by trial counsel at the trial court. In fact, not only is that directly contrary, that argument has been waived in its entirety. That was not raised at any point in the briefing in this case, nor was that an argument made at the trial court level, that this was in fact only the second attempt. The new target that was put in place at the motion for reconsideration, in this case that took place on April 30, 2019, as well as made a brief appearance in the initial appellant brief in this case, is that this was a sanction and the lower court should have considered the Kozel case and the 6 factors outlined by the Supreme Court for dismissal of a case with prejudice due to attorney misconduct. I would accentuate the terms due to attorney misconduct. Kozel is very clear that that is a case where the court's decision to dismiss was based, quote, solely on the attorney's neglect, end quote. That is not a case where there's been procedural deficiencies in the initial pleading, such as a failure to state a cause of action, which is, again, as Ms. Stein pointed out, has been conceded at the trial court level by counsel for Mr. Athey. So therefore, we know that Kozel is not implicated in this case. The court here explicitly stated that dismissal was for repeated failures to state a cause of action, again, a point which was conceded at the trial court level. The March 19, 2018 hearing is a microcosm of this entire case. There, plaintiff's counsel makes several acknowledgments and statements on the record, and that was the attorney who handled all of the amended complaints in this case, and actually all of the hearings leading up to the final hearing on the motion for dismissal, Mr. Sparkman. At that, counsel for the plaintiff explicitly acknowledged that the court had never threatened sanctions against him in this case. He states on page 14 of the record, "Your Honor has not chastised me and ordered me and said, this is going to happen if you don't amend your complaint one more time, if you don't get it right." Counsel goes on then to offer a suggestion to the court on page 17 of the transcript. If the court would like to make an order stating if there is a next motion to dismiss and it's granted by the court, it's with prejudice. He goes on to state he's fine with that suggestion because he believes, quote, the 5th amended complaint is sufficient. Again, counsel acknowledging there are several iterations of the complaint before the court, even at the time of the 3/19/2018 hearing, a hearing which Judge Thomas was asked specifically by all defense counsel to dismiss with prejudice. However, Judge Thomas wisely, in retrospect, stated it would not be fair because counsel was not put on notice of that issue at that time. That is the time in which she expressed on the record that she believed counsel was entitled, counsel for the plaintiff at that time, appellant now, entitled to the opportunity to amend one final time. However, counsel for the appellant points out that there was a mention of sanctions at that hearing, and in fact there was. However, the sanctions had to do with other conduct entirely. If the court would look at pages 50 to 51 of the record from that hearing, the court said specifically, in addition, the issues that I will address later with reference to sanctions has a lot to do with the fact that the rules of the 13th Judicial Circuit, which everybody should be familiar with, hasn't been complied with. There's the requirement which my colleagues and I are very serious about having to do with this collaborative effort. Counsel for the plaintiff acknowledged that he had not followed local rules at the time of that hearing and acknowledged that he had not attempted to collaborate in accordance not only with the local rules, but also the prior court order instructing him to collaborate and then integrate the suggestions made by defense counsel at the lower court level. When it came time to issue an order on this, counsel it was actually Mr. Willers at the trial court level, asked the judge if he can put in the order whether this is a last attempt on behalf of the plaintiff, which again was the language suggested by trial counsel for the plaintiff in this case. The judge specifically said no, because she did not want to give a false impression that this was going to act as a sanction. What this case lines up most closely with, Your Honor, in Florida law is the case that's been cited in the briefs of Myers. It's Myers versus Highway 46 Holdings, a 5th DCA case in 2011. In that case, there were numerous attempts by the Myerses to assert a cause of action. And the court concluded there that where the Myers have yet to state a cause of action, which is exactly what is the case here as conceded at the trial court level, the dismissal was not a sanction, and accordingly, Kozel is not implicated.
Mr. Bush, you've used up your 5 minutes, and then I gave you the extra minute Ms. Stein yielded. So you've got about 10 seconds to summarize if you need it.
I will end on that note, Your Honor. Thank you.
Okay, thank you. Who's got the last 5?
I do, Your Honor.
All right, Mr. DeLugo.
Thank you, Your Honor. Excuse me. May it please the court? My name is Michael DeLugo from the law firm of Wicker Smith in Orlando. I represent Dr. Fernandez and his professional association. And we adopt all of the arguments that have been presented on behalf of all of the appellees. But there is a unique issue that applies only to Dr. Fernandez. Dr. Fernandez was the individual who performed the Roux-en-Y procedure on Miss Athey. And the allegations of the various complaints that the appellants filed, excuse me, I apologize, were all allegations, excuse me, I apologize, Your Honor.
Don't worry about it. Take a drink.
Let me start over again. The allegations of the various complaints were that Dr. Fernandez failed to order certain diagnostic tests. But there was never an allegation in any of the various versions of the complaints that the appellants filed that that these diagnostic tests were not ordered in some sort of bad faith by Dr. Fernandez. Florida statutes section 766.102 subsection 4 directly addresses this particular issue and states, quote, the failure of a healthcare provider to order, perform, or administer supplemental diagnostic tests shall not be actionable if the healthcare provider acted in good faith and with due regard for the prevailing professional standard of care. There was never an allegation that Dr. Fernandez failed to order these diagnostic tests as a result of any sort of bad faith. The issue was raised in each of the successive hearings, in each of the successive motions to dismiss, and it was simply never addressed. It was never addressed in the initial brief. It was never addressed in the reply brief. It was never addressed at any point in time. And so in addition to all of the other reasons why the trial court should be affirmed, this unique issue as to Dr. Fernandez, the final judgment in favor of Dr. Fernandez should be affirmed.
Gotcha.
And I will leave it at that. Thank you.
All right, great. Mr. Castillo, you've got 5 minutes left.
Thank you, Your Honor. Please, the court. So let me go in reverse order. As to the bad faith issue as to Dr. Fernandez, it was alleged, in addition to failing to order additional testing after the surgery, that there was a failure to perform additional surgery following a report from the ICU stating possibility of post-op complications very high, et cetera, et cetera. And so we would disagree that that's untrue, or we would assert that that's not true. And then as far as case law goes, there's no case law on point as to that particular statute regarding bad faith, other than one that I could find from 1984, 4 Law v. Fitzer, 456 Southern 2nd, 432 for the record. It's a Supreme Court of Florida case. And that case involves a doctor who was prescribing Quaaludes to a client he knew was a drug addict. And the court applied the standard in that particular case, saying that he had to have acted in bad faith, or quote, a physician who prescribes a controlled drug in bad faith, or they say, or outside the course of professional practice acts in violation of the statute. So they expand the interpretation of the statute, which doesn't actually use the language bad faith. So nowhere in the case law of the statute does it actually have to say that you have to use the magic words of bad faith in your complaint to properly allege bad faith. But even still, or even be that as it may, it only applies to Dr. Fernandez and none of the other appellees in the case. As Mr. Bush and Ms. Stein appropriately pointed out, from the get-go, the lower court in this case forced the appellant to bend to the wishes of the appellees in their motions to dismiss and force the collaboration, which explains the numbers of the version, right? And they allowed the lower court essentially allowed the appellees to become the dog or the tail wagging the dog, so to speak. And so that's why you have these multiple motions for leave to amend, which contain the first, second, and third, and fourth, but you only have the granting of the amendment as to the fourth and the granting of the amendment as to, excuse me, or from the original and then the granting amendment to the fourth. So you only have 2 amendments allowed by the court. So as far as complaints go, only 3 have been filed and it was the third one to be dismissed. So, Your Honors, based on the holdings in both Cobham and Capley, there is no futility. There is a cause of action, I think, as implicitly acknowledged. Again, none of the appellees have argued that they've been prejudiced by any of this, even through oral argument now today. And it wasn't an abuse because, again, there was only 2 amendments allowed. And all the case law cited, including the Myers v. Highway 46 holdings, there was 4 iterations of the complaint. This wasn't an abuse of procedure. Under 1.190, amendments should be allowed as justice demands. Justice demands in this case, the only abuse was the abuse of discretion by the lower court. The decision should be reversed and remanded. Thank you all for your time.
All right, thank you all. Well argued. We're going to conclude these cases and move on to the next one. And that would be Baker versus Westfield.